Good evening, everyone. I think the technology may have caught up with us by now. I have been wishing for the last year that instead of doing degrees in international law, I'd done one in information technology. It would have been so much more useful. However, that's past history now. And indeed, tonight we are going back in history as well, because the AIRE Centre and Garden Court have worked together for as long as I can remember. The AIRE Centre is now nearly 30 years old, and we worked together with Garden Court even before we set up the AIRE Centre. Indeed, we consulted a number of Garden Court's barristers when we were considering setting up the AIRE Centre to see if they thought it would be a good idea. That was the days of Ian MacDonald when he was still a junior, Nick Blake when he was still a junior, all the Illuminati of Garden Court when they were young barristers. It was before the first edition of MacDonald on immigration, and it was a very, very long time ago. Now, I have instructions that I have to give you. I don't have to tell you where the loos are, and I don't have to tell you where the fire escape is, because that's one of the benefits of being on a webinar. But I have to tell you this. You have been placed on mute. Please post your questions in the Q&A window. The chat function is enabled for any other comments, queries, and/or feedback. Please do not post questions in the chat function. And as you're all lawyers, you will know the difference between a question and a query. Next, resources will be circulated to registered delegates after the webinar. I think that means you can go and get a cup of tea in the middle of doing this, and then you can catch up on it afterwards. Thirdly, this webinar is being recorded. So this means that the audio and video of the panelists and anybody else who's allowed to speak, if they're unmuted, will be recorded. And this webinar may be shared on our market hour, that's Garden Court, because the AIRE Centre doesn't have any marketing channels, including our website and social media. And fourthly, please refer to the very clear instructions in the chat window if you are experiencing technical difficulties. That was the hardest bit of the webinar. But after 30 years of the AIRE Centre and Garden Court working together, it's a great pleasure and honour to have been invited to chair this seminar with 4 really interesting speakers. I'm going to introduce each of them as they come into the webinar. The first speaker is Markella Papadouli. Markella and I first met when she was working for ECHR back a long time ago at a conference in Bologna, which was not a webinar. And she came to join the AIRE Centre shortly after that. She's a qualified Greek lawyer, and she's a registered European lawyer. I think that's the technical term for it, isn't it? She is an encyclopedic knowledge of EU and ECHR asylum law, and I'm not going to waste any more time making you listen to my voice. I'm handing over to her.
Thank you very much, Nuala, for this wonderful introduction. Good evening, everyone. My name is Markella, and I'm the AIRE Centre Europe Litigation Coordinator, and also a UK solicitor and Greek lawyer. It is an honor for me to be here virtually, although I have to say that I would much rather be celebrating this occasion of the 70th anniversary of the European Convention on Human Rights with all of you in person with some Strasbourg wine. And as you can see from the title of my presentation, I will be talking today about the progress and main achievements of the European Court of the European Convention on Human Rights in the area of asylum. A progress in development which, after extensive Googling, in dance patterns, I managed to make a parallel to a cautious old dance, 2 steps forward and 1 step backwards. Let me just move into the next slide. There we go. When I set out to do this presentation today, I quickly realized that it was not easy because I found myself trying to select the best cases in progress of the European Court of Human Rights in asylum. And I quickly felt that I was falling into the trap of cliches. Everyone knows and celebrates MSS versus Belgium and Greece, following a judgment following which all returns to Greece were stopped. And people from a surprising wide array of backgrounds seem to know some of the classic oldies like Soufiane Elmi or Tara Kell. The European Court of Human Rights has over the past years published a huge list of judgments on asylum, a number that becomes even more impressive considering that the European Court of Human Rights, the European Convention on Human Rights does not contain explicit provisions on asylum, unlike, for instance, Article 18 of the Charter of Fundamental Rights. The vast majority of judgments on asylum come within the context of violations of Article 3, 5, 8, 13, Article 4, Protocol 4, and Rule 39 of the Rules of the Court. So trying to overcome the cliches or the old asylum judgments, I decided to look into this year's top hits in asylum in an attempt to explain how they fit within the court's existing jurisprudence and landmarks and show what challenges lay ahead for the convention in the future. The main themes that I aim to explore in my presentation include the safe third country concept, access to territory, humanitarian visas, and children. So let's start with the first judgment ahead, which is no other than the long-awaited safe third country judgment of Ilias and Ahmed versus Hungary. The AIRE Centre assisted the fantastic team of the Hungarian Helsinki Committee with the representation of this case before the court's Grand Chamber. The case pertained, the case in question, and of course you can see the full details of all the judgments on the slides for your convenience, to two Bangladeshi nationals who transited through Greece and the Balkan route before seeking asylum in Hungary. They stayed in the notorious Rhuppiah transit zone for 23 days before they were returned to Serbia based on the safe third country concept. The applicants were returned to Serbia, as I said, they were returned to Serbia, and they complained that their return, as well as the conditions of their detention in the Rhuppiah transit zone, violated Article 3, and complained, among others, that the detention violated also Article 5, paragraphs 1 and 4 of the European Convention on Human Rights. The court, in that case, found a violation of Article 3 regarding Hungary's obligation to conduct an efficient and adequate assessment when applying the safe third country concept. The court also very helpfully found that when examining cases on their admissibility rather than on their merits, Article 3 imposes a duty on the receiving state to apply a thorough, comprehensive legal procedure to assess the existence of such risk by looking into updated sources regarding the situation in the receiving country. This finding came as no surprise, as it is based on solid foundation of previous cases on the issue, such as the celebrated rockstar of cases, MSS versus Belgium and Greece, and represents a very welcome development for future cases or cases currently pending before the court that deal precisely with the application of the safe third country principle for other countries like Serbia or Greece or others. Nevertheless, the case is mostly well known for its ugly side, the non-finding of violation of Article 3 or Article 5.1 or 4 regarding the detention in the Rhuppiah transit zone, a zone for which the Court of Justice of the EU found a violation later in 2020. So without focusing, however, too much on the restriction or criticism of the case, it has to be said that the court indeed took 2 steps forward and 1 step backward in this case regarding the application of the safe third country concept. So it is important to know that the court in that case consolidated the standards regarding the application of the safe third country principle, and also acknowledged the fact that because of the very nature of the court and the fact that the court assesses each case individually on the circumstances, Ilias and Ahmed, in fact, does not prohibit a future case being decided more favorably or differently, should perhaps the facts of the cases are different. The next case I have selected for today was another long-awaited case within the year, and that's called ND and NT versus Spain. The case pertained to the immediate return of two men to Morocco after their attempt to cross the Ceuta Melilla enclave. The applicants formed part of a group of 600 people attempting to cross the fence, and Mr. ND and NT succeeded in doing so, helped down by the Spanish police and handed over to the Moroccan authorities. The applicants complained of collective expulsion under Article 4, Protocol 4, and Article 13, given that they had no remedies available at their disposal to challenge effectively their return. The case of ND and NT opened a huge debate, especially after its relinquishment to the Grand Chamber, understandably, because it raised a very big question as to whether borders constitute a place in which state jurisdiction exists, and state obligation under the European Convention on Human Rights and under other articles, also under the Common European Asylum System, apply. Parallels with other cases where jurisdictional matters had arisen, of course, came into perspective and were unavoidable. For instance, the case of Hirsi versus Italy came also before the consideration of the court. That was the case concerning jurisdiction of Italy regarding handing back migrants to the Libyan authorities after them being rescued at sea based on a bilateral agreement. The case brought into perspective exactly the questions raised of questions regarding jurisdiction, and all eyes were on the court to rule on this particular issue and land borders. Disappointingly, but unsurprisingly, politically at least, the European Court of Human Rights found no violation of Article 4, Protocol 4 in respect of the applicant's expulsion to Morocco, highlighting also, and this is the interesting part, that the applicant's own conduct was relevant to this finding. The court found, rather shockingly, that the state had not failed to provide the applicants with genuine and effective means of entry. No violation was found of Article 13. ND and NT, I will have to share with you, is a case that I struggled, in my opinion, to find the two steps forward in respect of the court's jurisprudence. But if one tries really, really hard, and after all, it's 2020, and we all have to try really, really hard to find the positives in everything that happens in our lives, we can see that this case, despite its harsh findings and clear steps backwards in respect to the main findings, at least it gives us certainty as to two things. First, it gave us for the first time clarity in the issue of applicability of Article 4, Protocol 4 in the immediate and forcible return at land borders, making a distinction with situations, for instance, at sea, where circumstances are different and perhaps more dire, easier for practitioners. And secondly, it gave us what you can see on the slides as the two-tier test that practitioners can use as a very efficient tool in their litigation for the future if they attempt again, after overcoming the trauma of ND and NT, to litigate another case at the land borders. The next case that I have selected for you, and we have one more after this, is MN and others versus Belgium, in which the AIRE Centre acted as a third-party intervener together with its strategic litigation task force. MN and others versus Belgium concerns a family of Syrians from Aleppo who in 2016 requested a humanitarian visa from the Belgian embassy in Beirut, Lebanon. The request was refused. The applicants complained before the European Court of Human Rights that Articles 3 and 13 were violated on account of Belgium's refusal to issue a humanitarian visas to allow entry, a legal pathway of applicants to come to Europe. There was also an Article 6 complaint on which I would not focus for time constraints. Where this case came into perspective, it immediately brought to mind a case that had come informally in the attention of the AIRE Centre several years before, in which a little boy in Athens with a sibling in Sweden lodged a case to the European Court of Human Rights complaining about the inhuman conditions he had to endure in a park in Athens where he was being sexually harassed because of the inability of the Greek authorities to receive and register his asylum request, and the refusal of the Swedish embassy to take a family reunification application or an asylum request, allowing him effectively to reunite with his brother in Sweden. The European Court of Human Rights declared that case inadmissible and effectively avoided having to rule on what the role of the embassies is in relation to examining asylum requests or whether jurisdiction in embassies arises in Europe, especially given the context of the Dublin regulation. So when MN and others came into context, we all held our breath. This was the opportunity for the court to rule on legal pathways to accessing asylum in Europe. And this was an opportunity to also steer away from smuggling and other irregular avenues to reach protection in Europe. Unfortunately, unsurprisingly, in 2020, we were also disappointed. The court provided with clarity that Article 1 of the European Convention on Human Rights is limited to persons within the jurisdiction of the court. And when considering and other factors for extraterritorial jurisdiction, the court did not find, for the purposes of this case, any violations of Article 3 and 13 of the European Convention. The court ruled that the administrative proceedings that had been initiated by the applicants had been brought at their own initiative, and crucially, that had the court found a violation, that would enshrine a near universal application of the European Convention on Human Rights, imposing an unlimited number of positive obligations on states based on individual choice rather than geographical presence. And even though I have to say the ruling in itself is quite disappointing, it does leave to us a small beacon of hope. And the beacon of hope is found in Article 6, when the ruling says that the finding does not prejudice any actions taken by states to ensure and facilitate access to asylum procedures through diplomatic and consular representation. Now, a pessimist would say, great, so now we're left on the state's political will to do what they have to. But an optimist may choose to say, okay, it is what it is, and perhaps this is the first of the cases on this issue in a field calling upon access for legal pathways that is always ever developing. The last case I have picked for you today is Moustahi versus France, a case regarding children. And this is made mostly to end on my presentation on a more positive note. In this case, Mr. Moustahi and his two children, Comorian nationals, complained that upon their arrival in Mayotte, they were issued a removal order with the children. But in 2013, the children traveled to Mayotte on their own by boat and were intercepted by the French authorities. They were detained with other adults and pending their immediate removal. However, during their stay at their removal center, they were incorrectly associated with another adult, and they were even associated in the deportation proceedings from that other adult. So the children complained for violations of Articles 3, 5.4.1, Article 8, and Article 4, Protocol 4. So the court, in that positive and optimistic case, following its crystallized jurisprudence on this issue, found the violation of Article 3, especially because of the arbitrary detention of the children with unrelated adults and the conditions of their detention. The court further found violations in respect of Article 5.4 as a result of the children's inability to challenge the deportation order, and the violation of Article 8 in respect of the authorities' refusal to reunite the children with their father, which was a decision clearly not taking into account the best interest of the child. Further details on the violation you can find on the slide. But what is worth saying about this case is that the court solidified its commitment to taking into account the best interest of the child in any decisions that have to do with any actions that have to do with children. Things and principles that we can find in previous jurisprudence and the rock stars of cases such as Mubilanzila, Mitunga versus France, or a more recent HA versus Greece. The court put beyond doubt that the best interest of the child should always be the paramount consideration of authorities. It also very helpfully gave us the principle that children should not be held in the same facilities as unrelated adults, a principle that made the eyes of every practitioner litigating in hotspots in the Mediterranean sparkle, because it is something that they can take and run with. So, of course, the landmarks of the European Court of Human Rights and the benefits of the European Convention on Human Rights Protection do not stop here and are definitely not limited to past or clear victories. The Convention is a living instrument, and the future ahead is full of challenges, which the Convention will have to live up to. And fantastic human rights lawyers, as we speak all across Europe, are bringing cases every day, clarifying issues based on existing jurisprudence and looking ahead. The safe third country principle that was at question in Ilias and Ahmed is now still pending in a reincarnated form in the case of JB versus Greece, questioning the role of the EU-Turkey statement, and in SB versus Croatia. Reception conditions of children being held in detention with unrelated adults is under question in Darbo and Camara versus Italy and Travagli versus Italy, while relatively new issues like jurisdiction at sea, pushbacks at sea, and search and rescue at sea are now mean that the European Convention on Human Rights has to enter new waters, pun intended. And given these constant challenges, especially in the field of asylum, I am sure that you will all agree with me that we in Europe are all incredibly lucky to have the privilege of such a versatile instrument as the European Convention, and a very big responsibility to use it in the interest of those who have entrusted their fate on us. And returning back to my Cha-Cha analogy, the progress of the court, if we may say in the past 70 years, has involved definitely some missteps, much like the Cha-Cha, some awkwardness, but also some balance. And in conclusion, I think you will all agree that we are definitely stepping forward. Thank you very much.
The only thing that is missing here, Markella, is the tumultuous round of applause that would have greeted that presentation had we been live and everybody had been able to thank you for it. For me, it was a trip down memory lane, all my favorite cases, and they all trigger all the memories of all the late nights and endless cups of coffee morphing into wine that we had to drink when we were doing them. That was indeed a magisterial presentation, and I'm sorry that we didn't get you to do the Cha-Cha whilst we were at it. Thank you very much indeed.
But for your own benefit. Thank you, Nuala.
So now we're going to move from Athens, where Markella is ensconced, isn't she lucky, and over to wherever Mark is, at home, I think. Are you, Mark?
That's right, at home in London.
With William Morris on your background. I'm introducing Mark because he's now going to bring us back to the UK and to the Human Rights Act of 1998. The AIRE Centre and Garden Court have a long history in relation to the Human Rights Act. Between 1998 and 2000, Navi Aloualia, now sadly dead, and I toured England and Wales for the Judicial Studies Board, teaching judges of all levels, things like the Leasehold Valuation Tribunal and all kinds of different tribunals that we'd never heard of before, teaching them about the Human Rights Act and what it meant. We were not let loose on the Court of Appeal or the House of Lords as it then was, but I think we did about 20 or 30 training sessions for lower level judges in those 2 years. Many of them are, of course, now frightfully senior, so any of their misunderstandings about the Human Rights Act might be attributable to us. But I'm sure Mark doesn't have any misunderstandings. He will present you the Human Rights Act cases with the clarity that is permitted by the lack of clarity of some of the judges. Mark. Oh, I forgot to tell everybody who you were. This is Mark Symes from Garden Court. He's a barrister. He's been a barrister now for a long time. 2004 he was called. And we've worked together on many occasions. And I can't think of anyone better than to do you what he has described as the whistle-stop tour of the Human Rights Act. Mark.
Thank you much indeed, yeah. Well, Markella is a very hard act to follow, yeah, witty and scholarly at the same time, yeah. My tour de table of the most interesting, or possibly not most interesting, but some of the more significant Human Rights Act cases in the immigration context follows then. So one point you'll notice is that, the issue of how do we select these cases? How does one select them? It's difficult, yeah. There's so many to choose from. And I've aimed to choose landmark cases rather than unusual ones. And I've focused mainly on Article 8 ECHR, and it's interesting why I suppose that's happened, isn't it? It's quite notable that if you were to think of where the common law probably receives most help, the common law being famously good at protecting procedural rights, very strong in terms of protecting liberty and the right of fair trial, where the common law is probably at its very strongest, or at least strong, is in the right to family and private life, about which we'd be rather worried, I suspect, if we lost the Human Rights Act. So I think overall it was right perhaps to concentrate on these areas. So the first couple of cases I wanted to mention were Ulla and Doe and EM Lebanon. And those early decisions on the Human Rights Act established essentially that all the articles of the ECHR could potentially be applied in UK migration law. Inevitably over time, the ones that have seen the most attention, I suppose, are Article 3 and Article 8. But of course, others have certainly played a role. Article 5 ECHR appeared in the Saudi litigation, which perhaps established more in Strasbourg than it did domestically. A reminder of the courts working in some kind of partnership with each other. EM Lebanon was of great interest because it's a case which recognised definitively that every article was potentially available, but regarding some articles, there was an elevated test. And so that elevated test essentially was that you had to show a flagrant breach of the right in question where the breach took place extraterritorially. And that's why we now have this schism in that, for example, Article 8, private and family life, is normally approached directly in UK law because the breach happens when the person is expelled from the country. They leave their UK established private and family life. But what if the breach took place only abroad, as was the case with Ms. EM Lebanon, who faced the loss of her children via participation, if you can call it that, in Sharia proceedings in the Middle East? And the judges were very keen in that case. They made it very clear that they were not criticising or commenting, which would not have been appropriate, on the way that the legal system worked in Lebanon, but they were concerned to identify if a right was destroyed rather than simply damaged. And so that was a great step forward in EM Lebanon. Hardly ever have we seen another case where a right has been flagrantly breached, though there's been some suggestion in the fair trial cases that any significant breach of fair trial would be a flagrant breach. And then into the world of private and family life, so proportionality and Huang. And it seems a long time ago now that the question could even have been asked. Odd that the question could even have been asked, that could judges in appeals determine proportionality for themselves? These days, so far as the writ of human rights run, it's quite hard to work out in what human rights judicial reviews the judges can't determine proportionality, the old Wednesbury principles having given way to intensive review in all kinds of scenarios. But imagine, almost 20 years ago, there was a debate about whether judges could actually determine proportionality at all. And the House of Lords, of course, in Huang said that they should determine proportionality as opposed to just give deference to the Home Office. But in so doing, there should be a degree of respect for the Home Office institutional competence. One recalls over this period, there was also a debate over the language. Early decisions used to talk about the need to defer to the government. Later ones make it clear that the real question is respecting institutional competence, not slavishly following the government writ. Also, Huang told us that overall we had to balance the needs of society and the needs of individuals and groups. It was a bare balancing exercise, recognised in Huang, not a weighted one, to which we shall later come. Huang and family life, so Huang landmark not only on proportionality, but also on what is family life. And it's still, all these years on, it's still the go-to authority on what is the importance of family life to any particular appellant. Human beings are social animals and they depend on others. On the topic of scope of family life, Huang is obviously the classic authority on the importance of family life to individuals, but what of the scope of family life? And Lord Justice Munby, I think, was junior judge when he was summoned into the Court of Appeal to participate in Singh in New Delhi. So great was his expertise on family law and the human rights dimensions of it. And so Mr. Justice Munby gave this landmark speech in Singh in New Delhi about the value of recognising family life in all its manifestations. And of course, Strasbourg has always been very strong at recognising family life in terms of the nuclear family unit, perhaps less so in terms of the extended family unit. Over to Lord Justice Munby. He says that adoptive parents in this case had come from a society which embraced a faith very different from our own, and to which our law refused to afford recognition, though it was of profound importance and legal significance in their eyes. He stressed that in our multicultural and pluralistic society, the family takes many forms. And in so doing, he launched a journey which I doubt is over, but which had its most recent step in Aydin in the Court of Appeal earlier this year, where, not for the first time, the Court of Appeal opened up the scope of extended family membership, emphasising that the real test is not exceptionality or anything else, not exceptional compelling dependence, but simply whether support is real or effective or committed. Children. And one area in which the Human Rights Act has been very important has been putting neglected groups firmly on the judicial agenda. And it's true both of modern slavery and of children in modern slavery. It's so often said that people are hidden in plain sight. In children's cases, I recall it being said in the Supreme Court that they were all too often below the eye line of the court. And Zoumbas was one of the first cases that really developed the role of a child's best interest, emphasising the child shouldn't be held responsible for its parents' shortcomings or issues such as immigration history. ZH Tanzania, decided before Zoumbas, had emphasised the special importance of British citizenship. Before cases such as ZH Tanzania, the UK rather suffered from the fact that, firstly, for a long time we hadn't signed up fully to the Children's Rights Convention, and also that we hadn't signed up to the protocol on expelling our own nationals. So the recognition that a child was an anchor because of their UK citizenship was tremendously, tremendously important. And ZH Tanzania tells us that the loss of social and linguistic factors, the loss of the protection of your country of nationality, the loss of the health service were all tremendously important. More recently, we've seen the government has aimed to put the public interest more firmly on the judicial radar, concerned as it was that early decisions by the courts at all levels had led to inconsistency and perhaps had trespassed unduly into policy making, or at least had unduly disturbed government policies. And in Lebanon, we see that the Supreme Court recognises that actually the Home Office or the government is allowed to set policy. In fact, the Home Office is allowed to set it in rules which have a degree of democratic imprimatur, though not a lot, it would have to be said. But statute can certainly do so. And the great development in the last 6 or 7 years has been this battle between the courts and government about what the weighted public interest involves. The court in Lebanon said that actually the courts and tribunals should try and work together with the government in a collegiate partnership, not in a confrontation. And they emphasised that there's a big division between constitutional responsibility to set policy and the implementation of that policy in individual decision-making. Essentially, where someone couldn't meet the immigration rules, they could succeed so long as they could show a compelling case. We see the same debate in Hesham Ali and the deportation decisions. There, the Supreme Court have held that the government is allowed to set high policy, such as the fact that only very compelling considerations can outweigh the public interest, both in terms of preventing crime and generally deterring criminal activity generally. Both those dimensions are relevant. Finally, statutory presumptions. So these statutory presumptions have had a very strong impact in immigration appeals, particularly on private life. In general now, private life, which has been formed in precarious circumstances, which seems to be all circumstances, is to be given little weight. However, once again, the Supreme Court has come back even on that in Rhuppiah, telling us that actually, nevertheless, there always has to be some case-specific flexibility. Generalised normative guidance may be overridden in an exceptional case by particularly strong features of the private life in question. And so I hope that's helped you see the utility of the Human Rights Act in terms of the rights that can be argued in the UK case law, and in terms of appreciating quite what rights are most expansive in terms of their impact in UK law. That we haven't seen the last, I suspect, of the battle over constitutional responsibility in these cases. The most recent step on the journey has been in the EU dimension. The Home Office has, or the government has passed legislation by way of the 2016 regulations that try and limit the public interest in EU cases, whether or not they're dealing with family life or EU treaty rights. Anyway, on that note, I'll finish. Thank you very much.
Thank you, Mark. Thank you very much indeed. An excellent, not just tour de table, but tour de force, I think. Very good indeed. And very interesting arguments, I think, that the Human Rights Act enabled Council to make before the English courts. Arguments that wouldn't always have gone down terribly well in Strasbourg. We did in EM Lebanon, we tried very hard to persuade the House of Lords, as it then was, that the child we were acting for in EM Lebanon had the right under Article 6 to participate in the proceedings because it was going to be a determination of his civil rights, but they were having none of that. But instead they said we could come in as interveners rather than full parties. But we move on from that excellent exploration of the Human Rights Act's achievements to date, and we turn now to Louise, a barrister at Garden Court. And I don't think I've actually personally had the pleasure of working with you, but your reputation goes before you, behind you, and around you. And so it's a real pleasure to introduce you this evening. And you're going to talk about another often neglected group of people who the Convention on Human Rights doesn't do as much to protect as it should, and that's migrant women. Louise.
Thank you very much. I'm starting with. So in terms of the human rights of migrant women, not only the convention, but also the court have not done a huge amount. Do you have the right screen? You don't? No.
I'm not in charge of screens.
Bear with me a moment.
They're above my pay grade. There we go.
That should be the right screen.
Yes, perfect.
So not just the convention itself, but also the court quite often don't pay enough attention to migrant women. And this became really clear when I was looking at cases on migrant women over the last 20 years. And one of the reasons for that is that the court often takes the credibility findings of the domestic courts and is reluctant to go behind them. So you tend not to get good cases on migrant women who haven't been believed in the domestic courts. So going through this, I thought I'd start with a couple of landmark cases on women's rights that have been used in domestic cases, and then look at opportunities for the future. And underlying this issue, I think, is something that's dealt with quite a lot in the Istanbul Convention, which is a convention that I'm doing quite a lot of work with, which I'll come to at the end, which is that gender-based violence is often deeply rooted in social and cultural structures, norms and values that govern our societies. The trauma, stigma, shame and ostracism, secondary victimization and fear that women have are often barriers to disclosure, and that these infect our systems at all levels. So the case I'd like to start with is Aydin and Turkey from 1997. And this was a landmark case in that it recognised that rape by security forces was a form of torture. And both right across the board, we've been having issues with getting rape recognised as both a form of torture and a ground of persecution, because judges tended to think that rape was something done by individuals and wasn't part of a course of conduct by the state. And Aydin and Turkey made this absolutely clear. Moving on from that, the second case is Opaz and Turkey on domestic violence. And this was a landmark case not only on domestic violence, but also on gender-based harms. And in this case, the court found breaches of Articles 2, 3 and 14. Failure to protect a woman and her mother from attacks perpetrated by her husband, both directly and a failure to protect was found in the form of a failure to take effective deterrence measures. The court also found that victims of domestic violence fall within a group of vulnerable individuals entitled to state protection, and that physical violence and, importantly, psychological pressure of the type occurring within domestic violence amounted to ill treatment in the meaning of Article 3. And then one of the issues that's quite fundamental to the development of case law sort of following on from that was that domestic violence may be regarded as gender-based violence, which is a form of discrimination against women. So it's not just harm in and of itself, it's collectively considered to be a form of discrimination against women. And the court recognised in this case for the first time that the failure of states to address gender-based domestic violence can amount to a form of discrimination under Article 14. There are three areas where the court has considered or failed to consider specific forms of gender-based persecution. One is social exclusion resulting from things like adultery, or in the Shah and Islam sense, breaching social mores. And this is a case of N and Sweden, where there was an extramarital affair in the host country, risk of domestic violence following expulsion. And on the specific facts, the court found that if this lady was deported to Afghanistan, she would face various cumulative risks of reprisals from her husband, his family, her own family, and from society in general, which would create a real risk of a breach of Article 3. Forced marriage has been considered on a few occasions. I've noted two here, starting with AA and others in Sweden. This was a case of removal to Yemen. And in that case, it was found that because it was a family including two elder brothers who could provide the male support, there was no risk. And in WH Sweden, where the Grand Chamber was going to consider the issue of forced marriage, the residence permit was granted by the national authorities and the issue wasn't determined. Similarly with female genital mutilation, if the ECHR were to find a real risk of FGM, it would be very likely to make a finding of a breach of Article 3. But in most cases currently considered, either the finding is that individuals won't face a risk or a friendly settlement's been reached. And you'll see the case of Bangura in Belgium as an example, which was struck out on the grounds that no foreseeable risk. I was asked if I could make this presentation funny. The answer is probably not. There are two cases, one dealing with detention and removal. Detention, some good progress has been made. And the example that I've cited here is Abdi Mahmoud and Malta from 2016. This related to an extended detention of about 16 months of a woman with vulnerabilities owing to her health, who had no access to outdoor exercise at all for a period of 8 to 10 weeks and then limited access thereafter. There were a lack of female staff in the detention centres, little privacy, and a lack of specific measures to counter the cold, which the court found amounted to a breach of Article 3. There is also the case of Shoshvili and others in Russia is quite interesting because it relates to the expulsion of Georgian nationals from Russia. And in this case, the first applicant was the mother of 4 children, and she was pregnant. And they'd had an expulsion order issued against them and were en route to leaving. And they were stopped and prevented from continuing their travel out of Russia and held for a period of about 2 weeks without being provided with state assistance. They had limited means to provide for themselves and their temperatures were below -5. they found themselves living in a basement with many other people. And the court found that on the particular facts of that case, there was a breach of Article 3 owing to the very vulnerable status, the living conditions, and the indifference of the authorities. So what areas of hope are there for the future? And as I know Matthew's going to be talking about trafficking, I've not dealt with that at all in this presentation, but what you can see from the ECHR cases on trafficking is that they're increasingly using the Trafficking Convention as a guide to developing jurisprudence in respect of Article 4. And similarly, my expectation is that the court will use the Istanbul Convention to develop the jurisprudence in respect of women and migrant women. They've started to do it already in the context of domestic violence. And the Istanbul Convention is the convention on combating all forms of violence against women and domestic violence. The UK has so far signed it, but has not ratified. It has 4 provisions that affect migrant women in substantive ways. The first one is the non-discrimination principle at Article 4.3, which is probably the most important because it prohibits discrimination, including on grounds of migrant status, which would include undocumented migrant women. And it therefore applies all the principles and standards of that convention, including access to shelter, access to support provisions, psychosocial assistance and protection standards whilst in the territory to migrant women. Article 59 is specific provision for residence permits, which I'm not going to go through. Article 60 contains detailed provision for gender-based asylum claims, including reception and accommodation, identification of vulnerable victims, determination of asylum claims, and the provision of gender guidelines. Article 60 itself requires that gender-based violence against women is recognised as a form of persecution and as a form of serious harm. It requires states to ensure a gender-sensitive interpretation is given to each of the convention grounds, and requires states to develop gender-sensitive reception and support procedures, gender guidelines, and gender-sensitive refugee determination processes. And Article 61 of the Istanbul Convention refers explicitly to the non-refoulement principle and requires states to ensure that victims of violence against women who are in need of international protection, regardless of their status or residence, shall not be returned under any circumstances if it would result in a breach of the non-refoulement principles. What strikes me as particularly interesting about the way that the court might use the convention in looking at migrant women and asylum claims is the standards of protection and the way in which protection claims are analysed. Because my view of what happens in women's cases is they face a sort of double bind. Firstly, they're not believed, and secondly, it's believed that they will be able to find safety because they only fear their family. So looking at the protection principles in the Istanbul Convention is one way in which there may be a development of asylum claims or asylum protection in the similar way that trafficking claims have developed the jurisprudence on Article 4. The principles that would be applied are summarised in a case called Volodina and Russia from 2019. These are relatively familiar to I think, this audience, so I'm not going to go through those in detail. But the first one is the obligation to criminalise the form of harm that is feared. And this appears in the Istanbul Convention at Articles 29 to 48 and a case called ZB and Croatia. And the second thing is whether all relevant victims are covered by such legislation. So, for example, in domestic violence, it's not okay to exclude lesbian women or to exclude unmarried partners. And MG in Turkey was unmarried partners, and in X and Y in the Netherlands, it was a case of rape involving a child who couldn't make a complaint on her own behalf. There's also a welcome development in Article 3 cases, recognising the cycle of power and control that occurs in domestic violence cases and some gender-based violence, which takes into account the recurrence of episodes and likely escalating nature of violence when assessing whether risk is real and immediate. And it's almost a sort of variation of the Osman test to take into account the particular circumstances of domestic violence and the escalation of that. The other interesting development is the consideration of things like risk assessments, protective measures throughout any proceedings, including court proceedings, and the requirement to engage in rehabilitation work with perpetrators when looking at whether or not a state is in breach of its operational duty to protect women. And again, this is something that I don't say dictates what we should be looking at in asylum claims and asylum protection of women, but they're very useful considerations that could guide whether or not protection is in fact available. So my view is that the Istanbul Convention may well lead to a development of the Article 3 jurisprudence, not just in measures taken that are necessary for women to be understood, to put their claims forward and to be believed, but also in terms of the protection that they need in the future if there's not going to be a breach of Article 3. And finally, just because people might be interested in a sort of more fuller exposition of that, this gender-based asylum claims and non-refoulement Article 60 and 61 of the Istanbul Convention publication is available for free on the Grevio website. Thank you.
Thank you very much indeed. I entirely empathise with you being asked to be funny about something that seems to have nothing funny at all in it. It's comforting, though, to see that the court has started to come further than it was in the beginning. Portokrin Aydin, in the first case that you mentioned, the French would not even give her a visa to come with her baby to Strasbourg for the hearing, had not the indomitable Françoise Hampson of the University of Essex insisted. And Françoise is the person to whom we should all also be grateful, because she's the first person who drew the world's attention to Article 53 of the Convention, which means that instruments like the Istanbul Convention have to be incorporated into any interpretation of the European Convention on Human Rights if the respondent state has ratified them. So you'd think that even this government in this country could ratify the Istanbul Convention, wouldn't you? But no. Let's move on now to Matthew and developments in trafficking. Matthew, you are not developing trafficking, but you are going to tell us a little bit about developing trafficking. We know that Article 4 is non-derogable under Article 15 of the Convention, and we were very happy to be involved in Rantsef and a number of other cases like CN, and I'm sure Matthew's going to tell you all about them. Matthew is, of course, the director of the AIRE Centre. He needs no introduction from me. He's a solicitor. Before he was at the AIRE Centre, he was the director of the Prison Advisory Service. Matthew, over to you. You're muted. Mute.
Yes, thank you. Hopefully you can see the slides. I'm just going to talk a little bit about Article 4 of the Convention and the duties thereunder as a background, and then talk about a couple of cases that the AIRE Centre has been involved in. One of those cases, we have instructed counsel from Guard Court, one in the Supreme Court, and one in the Court of Appeal. So Article 4 is set out there. People will be familiar with it. Article 4.3 contains various carve-outs, perhaps the most obvious one being that any work required to be done in the ordinary course of detention, including prison, will not deemed to be forced labour. That's a handy get-out to pay for paying prisoners for all the work that they do, whether or not in the UK or across the continent. As Nuala says, unlike most of the substantive rights protected under the Convention, Article 4.1 makes no provision for exceptions. Article 4.2 likewise has no provision for exceptions, and it's worth pointing out that none of the exclusions carved out in Article 4.3 apply to human trafficking. Although Article 4 is expressed as a prohibition, it also has preventative components and also a number of positive obligations. And I want to just briefly look at those because that will inform actually how the cases in the UK courts were argued. So there is a systems duty, which is a general duty to implement measures to combat trafficking, and that could be seen in a case called TDT. And that general systems duty is both to punish traffickers and, importantly, to prevent trafficking. And to protect the victims is a general one, and that was seen in Chidren versus Greece, and as required by the Palermo Protocol and the European Anti-Trafficking Directive. There is also an investigative duty, which is triggered where there is a credible suspicion that an individual has been trafficked, and that can be seen in the case of CN. Credible suspicion means that the allegation is not inherently implausible, and the threshold could be crossed before case comes even before a competent authority. And so it can, for instance, be crossed at a time when a Home Office caseworker, for instance, decides to refer a case into the NRM. Again, that was seen from the case of TDT. There is also a protection duty. Again, that's triggered where there is a credible suspicion that the individual is at a real and imminent risk of being trafficked or re-trafficked. There is also, importantly for the next couple of cases, a soaring type duty, which is a duty not to send back an individual to another state where there are substantial grounds for believing that he or she would face a real risk of being subject to trafficking. The obligation correctly to identify a victim of trafficking forms a necessary element in each of the investigative, protection and soaring type duties. These positive obligations in Article 4, as has been highlighted by Louise, are also informed by the Anti-Trafficking Directive and also related international instruments. So it's well established that the European Convention can be interpreted by reference to the broader framework of international law, such as the Vienna Convention. And it's been repeatedly relied upon by the European Court in the context of trafficking cases and Article 4, as seen again in cases like Rantsev. The Council of Europe Convention Against Trafficking is intended to be a comprehensive legal instrument focused on the prevention of trafficking, prosecution of traffickers, and importantly, the protection of victims of trafficking. The European Court has expressly confirmed that whilst there may be no automatic read across in relation to the Anti-Trafficking Directive Convention, that the positive obligations inherent in Article 4 of the Convention must be construed in light of ECAT. In the context of trafficking, this can be seen in cases like Siliadan and also Chidren versus Greece. And the approach adopted is entirely orthodox and can also be found in the Article 3 Convention case law by reference, say, to the United Nations Convention Against Torture and cases like soaring. So how's that played out in relation to the UK cases? So the first case we're going to look at is MS and Pakistan. This was the Supreme Court's first opportunity to consider complex issues around the identification of victims of trafficking, and it focused on the relationship between the decision-making process of the competent authority in the UK, which people will be aware is the National Referral Mechanism, and the Immigration Appeals Tribunal. The facts of MS Pakistan were that MS had arrived in the UK from Pakistan at age 16, having been subject to forced and physical abuse whilst in Pakistan. In the UK, he was also subject to forced labour. The NRM, in his case, made a finding that MS was not a victim of trafficking. MS appealed the subsequent decision to remove him from the UK following an unsuccessful asylum claim by the immigration tribunals and the Court of Appeal, who rejected his case and said in short that the appropriate challenge to any NRM decision above and beyond a perversity issue had to be by way of judicial review. So MS Pakistan addressed whether or not an immigration appeals tribunal had to be bound to accept the decisions of the NRM as to whether or not a person is a victim of trafficking, and also the relevance of a finding that a person had been trafficked to any immigration decisions that come before the Immigration Appeals Tribunal. The Supreme Court, in overturning the Court of Appeal judgment, held that immigration appeal tribunals are in no way bound by decisions of the NRM, nor does it have to look for reasons as to why that decision is flawed, departing from the Court of Appeal and their reading of AS Afghanistan in particular. As Lady Hale noted in her judgment, which was unanimously agreed, this is an important matter. As the AIRE Centre points out, had the tribunal been bound by such decisions, it could have had a profoundly chilling effect upon the willingness of victims to engage with the NRM mechanism. The Supreme Court found in this case that the tribunal was better placed to decide whether or not MS was a victim of trafficking than the NRM, having heard live evidence from MS, which obviously the NRM did not. The Supreme Court also considered the relationship between ECAT and Article 4. Lady Hale ruled that once MS was found to have been a victim of trafficking, it was then necessary to decide whether or not his removal from the UK would amount to a breach of the positive obligations in Article 4. The court found that MS had not been allowed an effective investigation in relation to Article 4, and that the UK authorities were under a positive obligation to rectify such a failure. Such an investigation would not have been possible if he had been removed to Pakistan. While the court did not directly decide on what extent ECAT had been imported wholesale into Article 4, because in the end that matter wasn't directly an issue, there are lots of very relevant overturn remarks are in paragraphs 20 to 27 of Lady Hale's judgment, which is a boost for those who want to argue about ECAT applies domestically. The second case and final case, in fact, I want to look at is the case of MN versus IXU. MN and XIU, this is Secretary of State for the Home Department. So this was a case where we were assisted by a Golden Card team, including Stephanie Harrison, Gemma Loosley, and Ronan Toll. And the case of MN and IXU was before the Court of Appeal in the summer and has the potential to change the legal landscape for trafficking victims. That's what the Court of Appeal is looking at, and we would probably expect judgment before the end of the year. So under the current system, the Home Office makes conclusive grounds decisions applying a balance of probabilities test, which means that decision makers assess whether a person is more likely than not to have been trafficked. Arguably, this test is set unlawfully high and breaches the UK's duties under Article 4. This is because, as we've discussed, the protection and investigatory duty under Article 4, and that is informed by entitlements such as those set out in Article 12 of ECAT, are engaged whenever there is a credible suspicion of trafficking. Yet the application of a balance of probabilities burden of proof conflicts with the level of proof required to discharge Article 4 and Article 5.3 of the EU Charter and the positive obligations therein. This appears to us to be legally incoherent and results in a protection gap. In terms of the investigatory duty, the decision to prosecute an offence under the Modern Slavery Act is informed by the NRM process. If the balance of probabilities threshold is applied at the conclusive ground stage, for instance, to determine whether or not an individual is a victim of trafficking, there is a real risk that the investigatory duty under Article 4 and Article 5.3 of the EU Charter on the police, again triggered by a credible suspicion of trafficking, would be prematurely undermined or otherwise curtailed. It's not hard to think of common scenarios that illustrate the potentially disastrous interplay of a balance of probabilities test applied before the conclusion of a full investigation of a trafficker. An obvious example is that of a single victim's account, which in isolation seems implausible and inconsistent, but which, as an investigation by the police might reveal, is corroborated by, say, 3 other similar fact accounts. The credibility framework challenge also raises the point that the Home Office's approach is unlawful in failing to properly adjust assessments to be child-specific when determining child claims such as IXUs. And instead, we argue that the starting point is the approach adopted in the context of other protection claims under the Refugee Convention and under Articles 2 and 3 of the European Convention, and the guidance set out in cases such as AM and KV versus Sri Lanka. And that is my
muted. It's really interesting the way you brought the Strasbourg jurisprudence back into the UK courts with a sort of marriage between what Mark was saying and what you're saying. It's a really interesting take on how the trafficking works. Of course, we've now just had SM Croatia, which is an even more telling case. And we're hoping that we can put pressure on Croatia to deal with it properly at the point of the execution of judgments. Thank you very much indeed. Now we move on, last but of course not least, to Greg O'Kelly, who is been waiting patiently there, I think in his attic, hiding from his children. And he's going to talk about health. He said to me before the session started tonight, did I have anything to do with D in the UK? And I think I sweated blood, toil, tears and sweat over D and the UK, both at the Commission and at the court. Alan Simmons, a solicitor who worked at the AIRE Centre with us, and I wrote the Article 3 stuff, and we brought in a bright young barrister called Nick Blake, now recently retired as Mr. Justice Blake, to do the Article 13 stuff because we didn't trust ourselves to know the English law remedies well enough. So that was a very long time ago, Dee. Greg, you're going to talk to us about health, and health is the important thing and rather topical in 2020. Please. Greg, of course, is a long, old friend of the AIRE Centre and a barrister here at Garden Court. Welcome. Thanks, Greg.
Thank you very much, Nuala. I think in common with the general trend of 2020, my internet collapsed immediately before I started speaking, so I switched to using my phone. Hopefully that will continue to function. I want to talk about the development of human rights law in the migration context, in the context of health, as Nuala said. So you will get to hear my views on some of the pivotal cases from the European Court of Human Rights in respect of Article 3 and health. And you'll also get to see Nuala try not to interrupt whenever I get something wrong. She was in most of them. So Article 3, in the context of expulsion cases, Article 3 is the provision preventing people from being returned to situations in which they'll be tortured or subjected to inhuman and degrading treatment. I think that's pretty well known at this stage by most people practicing in the field. Originally, this was considered to apply only to the consequences of actions actually taking place in contracting states. However, in the case of Suring against the United Kingdom and also Chahal against the United Kingdom, it was held that Article 3 could also apply in expulsion cases where treatment abroad was either due to intentionally inflicted acts of the public authorities there or acts from non-state bodies from whose action the authorities could not provide protection. So in principle, in an Article 3 case, you could succeed where the issue was expulsion, but what about in the context specifically of ill health? Because the consequences of a naturally occurring illness are obviously different to, for example, torture by a state for political beliefs, to torture by a terrorist group that the state can't protect you from. So, for example, Al-Qaeda operating somewhere like Afghanistan or Iraq or Syria, or, for example, starvation as a result of a militia deciding to burn all the crops in a given area, such as what you'd see historically in places like Somalia. So D against the United Kingdom was the first major case to address the question of whether an issue could arise under Article 3 in the context of expulsion of a person who had a naturally occurring illness. And the applicant in D was a national of St. Kitts, who was arrested on arrival in the UK with a large quantity of cocaine and sentenced to 6 years imprisonment. In prison, he was diagnosed with HIV. D's prognosis was very poor. He was given 8 to 12 months to live. And the situation in his case was that his life expectancy, limited though it already was, would actually be reduced by half if he was removed from his support in the United Kingdom. The court found that removal will present a real risk of breach of Article 3, having regard to the effect of the withdrawal of medical support in hastening his death and the conditions of adversity he faced in St. Kitts, which might lead to acute mental and physical suffering. The court bore in mind the critical stage his illness had reached and his exceptional circumstances, and the fact that there was some assumption of responsibility for his care. And what I mean by that is that the United Kingdom had been providing him with care. Now, by the time the applicant in that case had been, by the time the case had been heard, he had already been admitted to hospital because his health had very seriously declined. The court in that case observed that aliens who have served their prison sentences and are subject to expulsion cannot, in principle, claim any entitlement to remain in the territory of a contracting state in order to continue to benefit from medical, social, or other forms of assistance provided by the expelling state during their stay in prison. But nevertheless, the fact that his circumstances on return would have been such that the Article 3 threshold was met. Importantly, there was no evidence to show the family members who were present would be able and willing to prevent him from being homeless and destitute and living on the streets. And that was another factor that went into the mix in deciding that there were those exceptional circumstances. The court concluded that Article 8 raised no separate issue, and so it wasn't necessary to consider that. And there was no further case on this in Strasbourg for another 10 years. No other case succeeded. There were some friendly settlements and circumstances that looked like they might succeed, but there was no actual decision on the same kind of issue until the case of Ken. And against the United Kingdom in 2008. It's a decade after G. It's at a stage when AIDS drugs had improved. I think I saw here. Yeah.
May I interrupt you, because a number of people are asking about your slides, and I think the answer is that you can't show the slides because your internet has gone. Am I right in that? Or is there anyone else in charge of the technology here who could be showing your slides?
I thought I was showing. That's obviously what the issue is. Apologies for that. Is that better?
Not really, because I can't really hear you now, but why don't you just carry on, and I think the organisers can circulate the slides afterwards. I apologise for interrupting you, but I think the slides... here we are. They're here now.
Good.
Wonderful.
Fine. This is all going as
planned.
Yeah, I found it out. I knew that Louise wasn't able to work any jokes into her system, so I thought I would try and liven things up in my presentation. So, yeah, and against the United Kingdom, 2008. Like I said, my supervisor when I was a pupil is, I think, in this case, in the attendees somewhere, and I distinctly remember when I was a pupil reading this case, sitting at Stephanie Harrison's desk with growing horror. It was a really shocking and disappointing case. The situation was that the drugs for AIDS and HIV had improved, but obviously it was still a fatal disease. The applicant was a woman from Uganda living with HIV. Hers was not a deathbed case. Her condition was stable, but without treatment, she would deteriorate and die within a few years. The government argued forcefully the finding for the applicant would place a burden on contracting states that went beyond what was agreed when the convention was signed. The court accepted if the applicant were deprived of her medication, her condition would rapidly deteriorate. She'd suffer ill health, discomfort, pain, and death within a few years. So a really serious situation. But the rapidity of that deterioration and the extent to which she would be able to obtain treatment involved a certain degree of speculation, particularly given advances in HIV treatment. It therefore did not amount to very exceptional circumstances, unlike the decision in D. Now, the idea that there was speculation involved in looking at how she would be affected by a return to Uganda as a reason for not investigating what faced her in return to Uganda really goes against the grain of Article 3 in general and the Suring test. And it's also really striking that the court in N took the opposite approach to what it decided in D and effectively presumed that because she had some family members there, they would care for her, despite the fact that it was her case that they wouldn't. And there was no evidence at all available to the contrary. And the court also backed away from the idea that the UK had in some way assumed responsibility for treating her, despite the fact she'd actually been receiving care in the UK for 9 years at that stage. And although the the other possibilities of exceptional circumstances were left open. This case was largely treated as meaning that an Article 3 health case could only succeed in the expulsion context where people were on their deathbed. And there was, if you were in the first tier tribunal, you would hear that from the office, presenting officers, not unusually from judges too. And the court also considered there was no need to consider Article 8. So, gradually there was a move away from N. The decision N wasn't uncontroversial itself. There was a powerful dissent from 3 of the judges in the judgment who actually said that, look, what's described in the facts here, it does in fact reach the threshold for breach of Article 3. There were then hints at an obligation on states to investigate the facts on the ground, where an allegation of Article 3 was alleged, for example, in Tarakel in Switzerland and MSS. Now, Tarakel was a case about removal to Italy of a family under the Dublin 3 regulation, where there was evidence of really poor conditions in Italy, but particularly for families. So families were being separated. And the court held in that case that where it couldn't be excluded that there was that a person would be returned to inhumane conditions, it was the duty of the returning state to dispel that doubt. So that idea of what was called the Tarakel doubt started to creep into. And in the Mwanje case in 2013, a concurring judgment of the court expressed the hope that the Grand Chamber would revisit the decision in N on the basis that it was hardly consistent with the letter and the spirit of Article 3. And not a single case succeeded in Strasbourg applying the N threshold. There were some that succeeded domestically. I had a couple that succeeded in the FTT, and I know others did as well. It was extremely difficult to succeed on the N threshold. Then came Papadouli. This is a case involving a Georgian national who was suffering from leukemia. By the time of the hearing, he had actually passed away. And the conclusion of the court in Papadouli was that a claim can succeed where substantial grounds have been shown for believing that an applicant, whether at risk of imminent death or not, would face a real risk of being exposed either on account of the absence of appropriate treatment or due to the lack of access to it, to either a serious, rapid and irreversible decline in their state of health, resulting in intense suffering, or to a significant reduction in life expectancy. So the decision in Papadouli has the effect that an Article 3 claim is conclusively not limited to deathbed cases. Although the Grand Chamber presented the decision in Papadouli as merely a clarification of the very exceptional circumstances threshold, it was clearly a move away from that threshold. And that's not an unusual approach. The same thing happened exactly when KRS against the United Kingdom was effectively reversed by MSS against Belgium and Greece. Prior to Article 8, the court considered that if the Belgian authorities had properly conducted the Article 3 examination and had properly and lawfully concluded that there was no risk of a breach of Article 3, they would then have had to examine the situation in respect of Article 8. But there was a family life element in Papadouli that wasn't present to the same extent in N and D. The court held that where an applicant had adduced evidence that supported an arguable risk of ill treatment, the duty was on the returning state to dispel that doubt. It was necessary to consider the foreseeable consequences of removal for the individual concerned and receiving state in the light of the general situation there and the individual's personal circumstances. And contrary to the approach in N, the fact that the appropriate healthcare was not available was not a defence. It was up to the authorities to verify whether the care generally available in the receiving state is sufficient and appropriate in practice for the treatment of the applicant's illness, so as to prevent them from being exposed to treatment contrary to Article 3. Not a question of ascertaining whether the care would be equivalent or inferior to that provided by the healthcare system in the returning state. There was then a distinction in the UK between what everyone knew the law was, which was Papadouli, and what everyone had to apply, which was the decision of the House of Lords in N, because of course that was binding, whereas the Strasbourg jurisprudence is not strictly binding, certainly in the lower courts. The Court of Appeal then in AM Zimbabwe, in the judgment of Lord Justice Sales, as he then was, interpreted Papadouli in a highly restricted manner, effectively depriving it of its benefit. Then the Supreme Court overturned that judgment and gave an authoritative ruling on the correct approach under the Convention to medical cases. The court held that the effect of Papadouli was that it was in fact possible for an Article 3 ECHR claim to succeed in circumstances other than deathbed cases, such as D, And the Papadouli was not a mere clarification of the decision in N, but a departure from it, which was clearly right. And of course, in the Court of Appeal, Mr. Justice Sales was able to rely on the fact that the court was pretending to just be interpreting very exceptional circumstances a bit further as a basis for limiting what in fact the court found. So what's next on Article 3? Well, there's a case called Sovereign against Denmark, where the fourth section found a breach of Article 3 in the context of a man with paranoid schizophrenia and complex mental health needs who was facing return to Turkey, and where adequate support to prevent him relapsing might not be available. He's somebody with very complex needs who not only had strong requirements in terms of the medication he needed, but also needed somebody to be there to make him take it, to prevent him deteriorating, in which case he'd be likely to commit offences. And for his mental health to collapse. There was a 4-3 decision in that case. It was a very strong dissenting judgment, and the matter went to the Grand Chamber in 2020, and that is likely to be a case of great significance. And I hope I didn't get too much wrong, and if I did, I'm sure Nuala will correct me, and that's all I wanted to say. Thank you.
Thank you very much indeed, Greg. As far as I could hear, you didn't get anything wrong at all, and I wouldn't dream of correcting you. Gone are the days when I would dream of correcting you. But Sovereign has now been heard in the Grand Chamber, and there are rumours flying around Strasbourg about when it might get a judgment. So that's quite an interesting one to watch. Thank you very much to all our speakers. Everybody has been terribly obedient to my instructions about not putting questions into the chat box, but they've not been obedient about putting questions into the Q&A box. So I think, how much more time do I actually have? Mark, Amy, who's the boss here for time?
We have 5 minutes left.
5 minutes left, okay. So we still have 82 participants. We've lost 10 people only. That's absolutely amazing at 6:30 that we've still got 82 people here. If anybody's got a question they would like to ask, that they've been too shy and retiring, because we know that human rights lawyers belong to a shy and retiring breed, could they put it in the Q&A box now so that we can see? And if you haven't got a question, but just got a comment, because I know you're all sticklers for protocol. If you've just got a comment, perhaps you could make a very short comment, just so that we don't fill the whole 5 minutes with one person with a very, very long comment. Is there anyone who'd like to say anything?
Nuala, I know
Louise, I don't need to let you in because you're already in.
Just while we're waiting to see if anybody does have anything to say, I'd just like to reiterate the comments that you were making about Navi, because it seems appropriate to do so. And he was very much on my mind when we were preparing for this, in the sense that I don't think you can separate human rights, the AIRE Centre and Garden Court from a proper full remembrance of him.
And it's touching to see that you are biting back the tears in the same way as we all do when we mention him. But thank you for bringing up his name again. Thank you. He is greatly missed. I see a question. Fran Weber, how seriously should we take the government's threat to leave the Council of Europe? And what would the likely effect on human rights be? Who would like to take that one? It's got to be a domestic UK practitioner. Mark, Matthew, Louise, Greg?
I'm happy to have a guess, but I mean, I think it's a political question. I think given that Cummings has been forced out, I think the government is likely to adopt a less confrontational role in the next year or two about constitutional issues. They're trying to have a fight on a lot of different fronts. I'm not sure if they are necessarily going to continue pursuing such an aggressive anti-civil society line, an anti-international obligations line. So it's hard to say, but I think the risk has very slightly receded. There are hardliners who are in cabinet who do want it. Like, for example, I think Michael Gove would probably like to leave the Council of Europe, but I don't know. I don't know how likely it is to actually happen. If they did, sorry, go on.
I think having been I was in Strasbourg when Russia were throwing their weight around. And I think having watched that, whatever the UK government wants to do, what it actually does and what it finds it's capable of doing are probably two different things. And if they think the Irish border is difficult to sort out, then leaving the Council of Europe and all that entails is probably significantly more difficult. Doesn't mean they won't try.
The other factor in terms of what Francis was asking about, the likely impact on human rights law. Obviously, the impact on human rights law would be probably catastrophic. But having said that, I mean, certainly, I think most human rights practitioners, certainly I have been for the last several years, trying to argue cases first and foremost on common law grounds and using human rights as more of a backup, because it's been so controversial, and also because if that does happen, if we do end up losing all of those rights, then we still have embedded in the common law as much as possible principles that we can then rely on to protect our clients.
I suspect they will content themselves now for gutting judicial review through their independent administrative panel, which seems quite an easy win for them. I mean, suffice to say, if you looked at any of the panelists, you would not see anybody who was supportive of judicial review as an overview of government policy and or holding them to account. But we shall see.
And I think we've now found that the UK is in the forefront, together with its best friends, Russia and Turkey, in opposing the new initiatives for the EU to accede to the ECHR. So now that they've left the EU, they can't make their voice heard from within the EU, so they're now making it heard from without. Let me see if I've got somebody else here with a question. No. Mark, are you trying to say something, or is there just somebody in somebody's background? Well, I think that we've come to the end, and oh no, wait, look, there's another little one here. Sonali Naik, Sonali, hi. I asked a similar question of Lord Justice Singh in a recent lecture he gave, and he stated, in the context of fairness of hearings, that the common law could provide much, e.g. Osborne and the Parole Board, and we should go to the common law first. What do you all think about that?
As nobody else has their microphone on, at the ALBA conference a couple of years ago, Lady Justice Aydin gave a tour of the origins of the Human Rights Convention, and she started off in, I think, 1917 with a convention whose name I can't remember, and explained that actually if you trace the development of human rights law, it comes from various attempts of to introduce human rights legislation in the UK first. And I think going back to the common law and the origins of the convention might be the way forward.
Well, with all respect to Lady Justice Aydin, she was wrong, because the first international human rights treaty was actually in Central America. And I can advise everyone to turn to a magisterial tome about the genesis of the European Convention on Human Rights, which if you ever have a need to read something heavy or to prop a window up that needs to be kept open, it's exactly the right size, just like the compounded family law reports, which are wonderful for propping up your laptop when you're doing Zoom calls. Can I thank, oh wait, no, there might be somebody else. No, it's gone. I think I I think we now have to bring this lovely evening to a close. Sadly, we can't all go off and have the customary glass of white wine or fizzy water for those who prefer it, but maybe sometime soon we will be able to do that. May I thank everybody who has contributed, to Louise and Greg and Mark and Matthew and Markella. And thank you very much to the technological wizards at Garden Court for enabling us all to speak to each other. And thank you very much to the long and wonderful relationship that the AIRE Centre has had with Garden Court for 30 odd years. And we hope we'll have it for the coming decades as well as the past ones. Thank you, everyone, and enjoy the rest of your evening.
Thanks, Nuala.